Welcome to IMG Insights, our video series that dives into topics relevant to multifamily real estate investing. Creating an estate plan to support family, loved ones, and favorite causes is fundamental to setting up a comprehensive financial plan. With that said, only a third of American adults have estate plans in place, and many with plans haven't updated them recently to capture new life changes. In this video, I talk with Jim Krupka, an estate planning attorney in California who we've had a great relationship with for years. Jim has the knowledge and experience to share valuable guidance for those who are either evaluating or just getting started on their own estate plans. It's important to note that Investors Management Group isn't providing legal or tax advice in the discussion. Our conversation is simply meant to introduce an expert who can lead us through some real-life examples and thought processes that support us in our own planning. Jim, thank you very much for joining me today. As you know, IMG is a sponsor of investment real estate. We're always emphasizing the importance of planning ahead and operating with a long-term perspective. Real estate benefits from unique tax treatment using the 1031 tax-deferred exchange and stepped-up basis as just a couple of examples. So there's overlap between long-term real estate investing and long-term estate and tax planning. You're experienced in these various topics and you're actually in the business of planning ahead to deliver your clients the best legal and tax outcomes. I'll let you introduce yourself and talk about your practice.
My practice is really emphasizes trust planning for the most part. I do have clients that only have wills, but I would say, probably 99% of my law practice is setting up revocable trust for clients.
That's excellent, Jim. Trusts are a good starting point for today's discussion. They're a valuable tool to avoid going through probate, which is the court process for determining the validity of a deceased person's will. Now, Jim, why would a person want to avoid probate?
Probate is one of the important topics to discuss when it comes to estate planning. If you don't have trust planning and you have assets, it's going to be expensive. For the first $100,000 of assets, this is in California, the probate fees are 4%. You can spend a lot of money on probate fees, and it's really completely unnecessary if you do your planning.
And in addition to the probate fees, the estate's paying attorney fees for the extra time and the effort that's required to inventory and distribute the estate assets. Jim, is there a real-world example you can share from your practice for how you've seen assets passing through probate?
I'm going to use as an illustration a client who I'm meeting with tomorrow. This is a married couple. They were in their early 70s. They both passed away just recently within a month of each other. Now, this is not, it's not completely unheard of when spouses die, very close to each other. It happened with my grandparents. And I'm sure that, anyone listening to this can probably think of situations in their lives where, relatives of theirs, married couples have died very close to each other. What happened in this particular situation was the clients had a house that was in their trust, but they had a bunch of bank accounts that were held in joint tenancy and over a couple $100,000 in bank accounts. The long and short of it was, because they both died within about a month of each other, when the second spouse died, there were no owners on the bank accounts. And so all those bank accounts had to go through probate. That wouldn't have been the case had they put those accounts into the trust. Or it wouldn't have been the case if the second spouse hadn't died so soon after the first spouse died, and it would have given the surviving spouse a chance to transfer those assets into the trust. But when you do estate planning, you really want to think it through. And so for bank accounts, for the large bank accounts that people have, those should go into the trust. And you have a situation like this where they're not in the trust and you wind up with a probate. But it wouldn't surprise me if on their retirement accounts, they probably named each other as beneficiaries, but they may not have named contingent beneficiaries. Those retirement accounts will go through probate also.
That's a good example and unfortunate to hear. So going back to the expensive probate for this client of yours, can you help us understand those costs?
Well, with this the client that I'm talking about that I'm meeting with tomorrow, there's a couple $100,000, and the probate fees on that are going to be $7,000, $4,000 for the first 100,000, 3,000 for the second 100,000. That's a fair amount of money to spend on only a couple $100,000. And if you're talking about real estate going through probate, the fees are even higher, because real estate probate is based on the fair market value. It's not on the equity. So it's the equivalent of paying a real estate commission after you die.
Talking about probate expense that way makes a lot of sense. And how about if we're considering the wrap-up time? What's the difference in efficiency when comparing settling the estate through probate versus a trust?
This example of my client for tomorrow. If everything had been in the trust, the administration will take probably just a couple of months. If we have to, going through probate, depending on the county where the person lived when they passed away, it's probably going to be close to a year.
That's a long process. The extra expense and time involved with probate are two significant reasons to move assets into a trust. Jim, let's shift gears to another topic where you can provide expert guidance, and that's in understanding the estate tax. Can you talk a bit about the estate tax limits and the options to minimize tax liability?
Well, the estate tax laws are really kind of interesting. They've changed a lot over the last few years. The exemptions are now 12.9 million per person. So for a married couples can exempt 25.8 million. A single person, 12.9 million. Now, when it comes to trust planning for married couples in community property states, there's some very interesting planning that we can do. If you're a married couple in a community property state, it's possible to set up your estate plan in such a way that you can minimize or eliminate capital gains taxes at the first spouse's death as well as at the second spouse's death. In order to accomplish this in the most efficient way, it would be incumbent upon the couple to have what I would characterize as a simple trust. It's also called a disclaimer trust. And the way that works is when the first spouse dies, everything goes to the surviving spouse. Now, I'm just going to use as an example, let's say someone has an estate of $10 million. One spouse has died. And so there is now a $5 million estate for the surviving spouse and a $5 million estate for the spouse who just died. So the decedent's estate has $5 million. The surviving spouse, his or her estate has also $5 million. There's a law called portability, and this was passed over the last few years. The portability law is just as powerful, if not more so, than the higher exemptions that we now have. And the exemptions, by the way, have gone up exponentially. It wasn't that many years ago that the exemptions were $1 million per person. They're now 12.9.
Jim, you used the term portability. Can you please expound on that?
Portability gives us even that much more ability to avoid estate taxes. So let's use the $10 million example. Spouse has passed away. The decedent has $5 million in his or her estate. Well, the exemption from estate taxes is almost 13 million. It's 12.9 million, which means that there's almost $8 million of unused exemption. Well, before the portability law passed, if there was unused exemption, it was just down the tubes. You wouldn't be able to use it. You know, if you can't use it when the first spouse dies, you lose it. But now it's possible to save it. And the way that's done is when the first spouse dies, there's an informational estate tax return that's filed. There's no tax that's paid. It's merely an informational return. And you check the right box on the return that elects portability. So in this instance, we'd be able to move $8 million, 7.9 to be exact, of unused exemption from the decedent's estate to the surviving spouse's estate. So now the surviving spouse can exempt 7.9 million, plus their exemption of 12.9 million. And so that even if the estate tax laws changed and the exemptions went down, the surviving spouse would have $8 million of unused exemption that would be stored from the first spouse's death. And so what we're able to accomplish with all of this is that the entirety of the estate can be pushed from, originally we have two spouses. When the first spouse dies, everything goes to a survivor's trust, which is completely revocable and amendable. And all the assets, all 10 million of the assets would pass through the survivor's trust. What this means in terms of capital gains implications, first of all, when the first spouse dies, there's a full step up in basis on all the assets. This is because the assets were held in the trust as community property. And in a community property state, you get a full step up in basis on the community property assets when the first spouse dies. The surviving spouse could therefore sell the assets, all $10 million of assets, and not pay any in capital gains taxes because of the basis moving up to $10 million. And because the assets are being transferred at the second spouse's death, also through the survivor's trust, the survivor's trust will get a second step up in basis when the second spouse dies. So, for example, if the assets when the second spouse dies are now worth $15 million, date of death value, and the heirs inherit the assets for $15 million, they sell the assets for $15 million, and they don't pay capital gains on any of it. Capital gains taxes are the next tax battle to wage. And that's a battle that can be won if we do it with the proper planning. And the best way to plan it is to have everything go to the surviving spouse in a survivor's trust.
So once the second spouse dies and assets are passed to beneficiaries, how does the capital gains tax come into play?
Let's fast forward to when the second spouse dies in this illustration. The assets are worth $15 million when the second spouse dies. Well, it's good news. It's good news in terms of taxes because, first of all, in terms of estate taxes, the $15 million is under the $25.8 million. So there's no estate tax. In terms of capital gains taxes, there will be a full step up in basis at the second spouse's death to the $15 million level. If the heirs sell the assets for $15 million, they don't pay a penny in capital gains tax. If they hold the assets for, let's say, a couple of years and then sell them, let's say they sell the assets for $18 million, well, there would be a $3 million gain on that. And so unless they did a 1031 tax-deferred exchange, they would pay capital gains on the $3 million. The date of death values will determine the new basis.
That's an excellent example. In that example, you're introducing the 1031 tax-deferred exchange concept, and that's the provision within the tax code allowing real estate owners to defer taxes indefinitely. In fact, taxes may be deferred all the way up to the owner's date of death, at which point the beneficiaries of the real estate can use a stepped-up basis, which eliminates capital gains tax at that time. I've heard this strategy referred to as the swap till you drop, and it's a powerful end result if you're willing to commit to a long time horizon.
You're telling a very good story. It's a story that brings a smile to my face, and it's the way that I like to conduct my business as an investor. Personally, I've been doing 1031 exchanges since 1980, so I'm a big believer in it.
Jim, what are some of the questions you ask when you're assessing someone's complete financial picture, whether that's creating a new plan or even updating an existing one?
Well, there's one of the big considerations are the family dynamics. Are there children? Is it a married couple? Is it a blended family? Are the children from the spouses the only children that they have together? The family dynamics are very important because oftentimes with a blended family, you wind up having to do a fairly complex estate plan because there's concerns about, well, what if I die first? Do I trust my surviving spouse to not favor his or her children over mine? And so when you get into those kind of blended family situations, they oftentimes will require some complex planning. So that's a consideration. If it's a first marriage, it really opens the door for more simple planning. There can still be simple planning with blended families, but oftentimes it's not going to work. And then the other big thing is to go through the assets one by one to see all the different assets that someone owns, if they have LLCs, if they own real estate, if they have stock accounts, bank accounts, retirement assets. Part of the process is to go through each of the assets one by one. So it's the assets and the family dynamics. Those are the two areas of importance as far as I'm concerned.
That's good, and I'm sure it's helpful from your perspective. You have a client showing up with a really organized inventory of assets. You get a global view of what they own and how they want that handled after they pass.
Yes. What you just mentioned, Dave, is extremely important because when someone comes into an appointment with me and they have that level of organization, I know that they're serious. And that's a good thing. You have to be somewhat serious minded to do this stuff properly.
Making decisions about how assets, including real estate investments, will be passed on may seem too complex to get into. That's probably a big reason why so many people never even establish an estate plan. And for those who do, they might procrastinate on keeping it up to date. Jim, what are the downsides of not keeping an estate plan current?
If it's an older trust, the chances are pretty good that it's an AB trust, which is a complex trust. And with a complex trust, we're not going to get all the benefits that were just outlined. So for many of my clients that have been long-term clients, maybe I haven't seen them since 1995. We talk about, a different way to set up their estate plan. And I would say almost 100% of the time, they're very eager to enact those changes and to simplify their estate plan and to make it more efficient. So, anyone listening that has an old trust, it's probably time for a review.
That's a really good point. If you're updating your plan, you want to make sure the inventory of your trust is current and that your assets are titled in the right way. To your comment, it's something to take very seriously.
You're not going to get to this point of investments of this magnitude if you're not serious. And so, if you're serious about this, you'll make sure that your assets are titled properly. You'll make sure that you have a proper, up-to-date inventory of your assets. All that is extremely important.
That's excellent encouragement. We appreciate the conversation and the better understanding of some key estate planning topics. Thanks again to Jim Krupka for the wonderful discussion. For more information on estate planning documents, I invite you to visit jimkrupkalaw.com and contact Jim directly. Jim has some great information, and his contact information is at his website. We hope our webcast is a valuable resource for our investor community. This concludes our video for today. Thank you all for joining us.